Welcome to Module 2 on the Employment Standards Act, or the ESA as we'll be referring to it throughout this presentation. The ESA was significantly revised in November 2017. However, many of those changes were dialed back in November 2018 with the passing of Bill 47. We will present the updated version of the ESA as of November 2018 in this presentation.
The important thing to understand about the ESA is that it is the baseline for employee rights in the province of Ontario. It sets the minimum standards, which are the minimum entitlements for employees, and the corollary of that is, of course, the minimum obligations of employers. It is not possible for an employee or a union on behalf of an employee to waive employee rights. However, so for example, overtime is required to be paid at time and a half after 44 hours per week under the ESA. However, as a result of earlier amendments to the ESA back in 2000, there were a number of areas in the Act which were the subject matter of possible agreements, generally in writing, between employers and employees. So going back to the overtime example, it is open to an employee and an employer to agree to average overtime over 2 or more weeks, so that if the employee worked a lesser amount in the first week and a greater amount in the second week, the 2 weeks would be averaged, and it would only be if the agreed upon amount, such as 80 hours over 2 weeks, was exceeded, that the overtime would be payable.
Most employees in Ontario are covered by the ESA. Two main exceptions that are relevant for municipalities are federal employees. So any employee of a federal undertaking, such as a bank, an airline, post office, radio stations, etc., they're not covered. And closer to home for the municipalities, students are generally not covered, meaning students that are perhaps working under a work experience program coordinated through a high school or a college. In terms of unionized employees, the ESA still applies to them, and the Act applies to collective agreements. However, there are dispute resolution processes contained in collective agreements known as grievance and arbitration processes. And generally speaking, employees are required to follow those processes if they allege a breach of the ESA or other pieces of legislation such as the Human Rights Code or the Occupational Health and Safety Act.
This slide contains the definition of employee under the Act, which, as you can see, is very broad, especially paragraph B, which refers to the supply of services in exchange for wages. So that covers many working relationships, obviously. On the next slide, we'll get into the concept of independent contractor, and often there's an issue as to whether a particular person is an employee or an independent contractor of an employer.
Section 5.1 of the ESA was introduced in November 2017, and it essentially expands upon Section 5 of the ESA, which prohibits employers and employees from contracting out of the ESA. Now, Section 5.1 prohibits employers from treating employees as contractors or as any other non-employee entity. And this is because workers who are not employees, who are truly not employees, are not entitled to the minimum standards set out in the ESA. So Section 5.1 is essentially saying that if you have a worker who is truly an employee, you can't characterize them as a contractor in order to avoid the minimum standards of the ESA.
The ESA regulates some aspects of the issue of wages. It sets minimum wage levels for regular employees and for students, and it contains certain requirements about record keeping and how wages are to be paid to an employer's employees.
Of course, the minimum wage that is set out in the ESA is the lowest rate that an employer can pay an employee. There is a general minimum wage, which currently is $14 an hour, and that applies to most employees. There are a series of exceptions. The one most applicable to municipalities would be students. So there is a lower minimum wage that applies to students under 18 years of age if they work 28 hours a week or less when school is in session, or if they are employed during a school break or summer holidays. One other note that we often get questions about is employees who are paid on commission. Even employees who are paid on commission have to be paid the minimum wage, so there would have to be a calculation of the number of hours worked and the compensation received, and there would have to be an assurance that the employee receives at least the minimum wage.
There are certain specific requirements about what information employees are entitled to receive from their employers. Most of them are fairly obvious. So we have the pay period, the wage rate, the gross amount of wages and how those wages were calculated. That might be obvious if it's an hourly rate, or it might be contained in an employment contract or somewhere else. The amount and purpose of each deduction, anything paid for room and board, and finally the net amount of wages to be paid to the employee. The employer is required to establish a recurring pay period, which could be weekly, bi-weekly, semi-monthly, or monthly. I don't think I've ever seen a pay period that extended beyond a monthly time frame. And all of the wages earned in each pay period are to be paid no later than the employee's payday for that pay period. The wages must be paid at the workplace or some other place agreed to between the employer and the employee. And if the method chosen by the employer is direct deposit, then the account must be in the employee's name and no one else can have access to it again unless the employee has authorized that in writing. And there must be a reasonable proximity between the workplace and the financial institution to which the payments are made, again, unless the employee has agreed otherwise. Other than the usual deductions for benefits and CPP tax and EI, there are only certain other allowable deductions. Statutory ones, such as the three I just mentioned, a court order authorized deduction, so that could be child support or some other debt. And finally, written authorization by the employee, but any such authorization must either specify the amount of money to be deducted or provide a method of calculating the specific amount to be deducted. So it just can't be a open-ended written authorization. It has to be quite specific. There are a couple of specific prohibitions. First, an employer cannot make deductions from an employee's wages if the deduction is to cover a loss due to faulty work, and that would extend to damage sustained to an employer vehicle as a result of an automobile accident, and also if there is a cash shortage and the employee in question did not have sole access to the cash or property that was stolen. The ESA regulates both vacation time and vacation pay. In terms of vacation time for employees with less than 5 years service, the minimum entitlement is 2 weeks. After each vacation entitlement year, for employees with 5 or more years of service, the new entitlement with the November 2017 amendments is 3 weeks after each vacation entitlement year. In terms of vacation pay, the minimum requirements are for the 2 week entitlement 4% and for the 3 week entitlement 6%. of wages. So the question is, what's included in wages? The definition of wages in the Act includes regular wages, commissions, bonuses, overtime pay, public holiday pay, and termination pay, but does not include vacation pay, tips and gratuities, discretionary bonuses, and the like. The ESA also regulates when vacation pay is to be paid. The general default rule is that it is paid in a lump sum before taking the vacation. However, there are four exceptions which are listed on the slide, and I won't go through them, but taken together, they create some flexibility on the issue of vacation pay, and I find that some employers have certain cultures and practices around that issue that the ESA allows them to agree on as long as that agreement is in writing. The ESA provides for 9 public holidays. Note that Easter Monday and the civic holiday in August are not included in the list. Most municipalities will provide 3 or 4 more public holidays on top of the 9 required ones.
There were some tweaks to the manner in which public holiday pay was calculated when the November 2017 amendments were introduced to the ESA. However, those tweaks were very quickly dialed back and reversed when employers were experiencing some problems with the new method of calculation. So currently, as the ESA sits now, public holiday pay is calculated by taking the total amount of regular wages that the employee earned in the 4 weeks before the work week in which the public holiday occurred, and then taking that number and dividing it by 20, which essentially is the number of working days in a standard 4-week period.
Most employees have the right to refuse to work on a public holiday, get the day off, and receive public holiday pay. If the employee does agree to work on a public holiday, then there's 2 ways that he or she can be compensated. The first is to be paid regular wages for the hours worked on the holiday and receive another regular working day off with public holiday pay. And in that event, with the November 2017 amendments, requirement is that the employer provide to the employee in writing a statement as to when that second day is going to be taken off. Or alternatively, if there is an agreement in writing, then the employee will receive public holiday pay for the public holiday itself, plus premium pay at 1.5 times for all hours worked on the public holiday. But in that event, there is no other day to be taken off. Some employees can be required to work on a public holiday pay, although most of the scenarios do not apply to a municipality because they relate to the hospitality industry. And on the previous slide, I reviewed the ways that the employee can be compensated. That's the employee who does work on the holiday. And it should be noted that the employer, not the employee, chooses which of the 2 pay options will apply. As mentioned earlier in this module, the ESA has a minimum requirement of payment for overtime at 1.5 times the regular rate of pay for all hours worked in excess of 44 hours in a work week. As I also mentioned earlier, that can be varied by agreement between the employer and the employee. Certain jobs are exempt from the overtime provisions. The categories that are most relevant to municipalities are firefighters and managers and supervisors. Note that the managers and supervisors have to regularly and consistently perform managerial or supervisory functions. If they perform, quote, bargaining unit, unquote, work on an irregular or exceptional basis, that won't interfere with their categorization as manager or supervisor. If it's anything more than that, then they are at risk of being found to be regular employees and entitled to overtime. It should be noted that the ESA only regulates weekly overtime. In other words, there is no requirement in the ESA that overtime be paid for an employee working longer than an 8-hour day, for example. It is possible that a contract of employment or more likely a collective agreement would contain such an entitlement, but the ESA doesn't deal in daily overtime. As most people know, overtime is 1.5 times the regular rate of pay. And there's a simple example there at the end of the slide to make it clear. As previously mentioned, it is open to an employer and an employee to agree in writing to average the employee's hours of work over a period of 2 weeks or more. And that will appear either in a standalone document or an employment agreement or a collective agreement for a unionized employee. And in addition to having the written agreement, there must also be approval from the Director of Employment Standards and other fairly technical conditions, which are most easily accessed on the Ministry of Labor website. There are now specific call-in pay entitlements, which are a bit different than what existed in the Act before November 2017. Essentially, if an employee who normally works more than 3 hours is called in and work is not available for reasons other than reasons out of the control of the employer, such as weather and power failure and the like, then the employee is entitled to pay of 3 hours at the employee's regular rate. There is an alternative entitlement which is unlikely to occur very often. One scenario would be that the first 2 hours, for some reason, of the 3 hours are overtime, and then the remaining hour is at the regular rate. So whichever produces the higher entitlement for the employee is the one that will govern. As mentioned in connection with the last slide, if the reason for the reduced hours is something beyond the control of the employer, such as a fire or a power failure or other acts of God, then the minimum entitlement will not be applicable. And it's also good to know that the employer is entitled to give other work to the employee for the 3 hours. So it's not just a situation where the employee can show up, discover there's no work, and disappear. If the employer has other available work, then the employee can be required to perform that for the 3 hours. The ESA also contains daily and weekly limits on hours of work. So the general rule for daily hours of work is 8 hours in a day or whatever other number of hours is the established regular workday in that particular workplace. And for weekly hours of work, we're talking a maximum of 48 hours. Please note that this is separate and apart from overtime entitlement. These are absolute limits on the number of hours of work that an employee can perform in either a day or a week. Daily hours of work are an area where an employer and an employee can agree in writing that the employee may be required to work more than 8 hours a day or whatever the established regular work day is in the workplace. Similarly, an employee or a union on behalf of the employee can agree in writing that the employee will work more than 48 hours in a work week, but only up to 60 hours. And approval from the Director of Employment Standards is required for these types of agreements. And also please note that there is an anti-reprisal provision in the Act such that if a particular employee, because of childcare or any other reason, doesn't want to enter into one of these agreements, they cannot be penalized or disciplined or reprised against in any way. There are also provisions in the ESA dealing with rest periods and hours free from work. So on the daily level, the employee must have at least 11 consecutive hours off work each day, with an exception for on-call scenarios. Between shifts, there must be at least 8 hours off work between shifts, unless the total time worked on the shift before and after the rest period is less than 13 hours. And on a weekly basis, there must be 24 consecutive hours off work, or a bi-weekly basis, there must be 48 consecutive hours off work in every period of 2 consecutive work weeks. There are some exceptions to the hours free from work provisions which are relevant to municipalities, which entitle the employer to require an employee to work more than the daily or weekly limits, or during a rest period, but the test is a fairly stringent one. That requirement can only be made to avoid serious interference with the ordinary working of the employer's establishment or operations. And that's further defined as dealing with an emergency, an unforeseen situation where the continued delivery of essential public services is at issue. Again, an unforeseen situation to ensure the continuous processes or seasonal operations are not interrupted, or to carry out urgent repair work to the employer's plant or equipment. The ESA also provides for minimum requirements around eating periods. So every employee is entitled to a 30-minute eating period free from work after 5 hours of work. That 30 minutes can be split into two 15-minute time frames, or I suppose three 10-minute time frames. That is an agreement that does not have to be in writing. The eating periods are generally unpaid unless a contract or a collective agreement requires otherwise. And contrary to popular belief, the ESA does not regulate coffee breaks. Coffee breaks are not a statutory entitlement under the ESA, but again are often dealt with in collective agreements.
There are at least a dozen leaves protected by the ESA. These leave provisions were significantly changed in both the November 2017 and November 2018 amendments to the ESA. We will cover the leaves of absence that are bolded on the screen, but if you have to manage one of the other leaves, we recommend you review the MOL website to review the criteria for these other leaves.
The pregnancy and parental leave provisions of the ESA were slightly amended in the November 2017 amendments, but generally speaking, the processes, timeframes, etc., which existed previously are still in place. Essentially, a pregnant employee who has at least 13 weeks of service with the employer is entitled to a 17-week unpaid pregnancy leave. The employee is required to give at least 2 weeks' notice in writing to the employer of the day that the leave is to begin, and if the employer requests it, the employee is to provide a medical certificate as to the due date. The leave typically will end 17 weeks later, but in those few circumstances where the employee is not entitled to parental leave, it ends on the later of 12 weeks after the birth, stillbirth, or miscarriage, or 17 weeks after the leave began. If a pregnant employee who is on leave wishes to terminate her employment before the leave expires or when it expires, there is an obligation on that employee to give the employer 4 weeks written notice. The two cases at the bottom of the slide generally involve similar situations where the employer tried to manipulate the situation with the employee so as to get rid of the employee who had taken the pregnancy leave and to retain the temporary employee hired in her stead. Generally speaking, that is a very hard goal to achieve for the employer, and there are very strong anti-reprisal provisions in the ESA which surprisingly permit an employment standards officer to both reinstate the employee to employment and to grant damages for loss of employment, which can be in the tens of thousands of dollars. Parental leave is a separate entitlement from pregnancy leave and is covered under the ESA. New parents who have been employed for at least 13 weeks have this entitlement. The definition of parent is broad. It includes a birth parent, an adoptive parent, whether or not the adoption has been legally finalized, and a person who is in a relationship of some permanence with the parent of the child and who plans on treating the child as his or her own. A birth mother can take both pregnancy and parental leave. Both parents can be on leave at the same time. If the mother takes parental leave, it must be taken right after the expiry of the pregnancy leave, whereas if the father is going to take some parental leave, that must begin no later than 78 weeks after the date the baby was born or came into the custody, care, and control of the parents. The length of the parental leave for birth mothers is up to 61 weeks. That used to be 35 weeks prior to the November 2017 amendments, but what happened at the same time was the EI program was amended by the federal government so as to provide for the payment of 12 months worth of EI benefits over an 18-month time frame. So that's why we have a total of 78 weeks potentially if you add the 17 weeks of pregnancy to the 61 weeks of parental leave. If the employee wants to end the parental leave early, then 4 weeks notice in writing is required to be given to the employer, and similarly, as was the case with the pregnancy leave, if the employee wishes to terminate his or her employment, there needs to be 4 weeks written notice given of that as well. Employees of any status, as long as they have 13 weeks of service, are entitled to both pregnancy and parental leave. And the Act is very clear in that such employees are entitled to be reinstated to their former position or a comparable one if the original position doesn't exist. And I've mentioned in connection with an earlier slide that there are very strong enforcement anti-reprisal provisions in the ESA for employees who believe that they have been reprised against by virtue of the taking of one or both of those leaves. In the November 17 amendments, the length of this leave was increased from 8 weeks to 28 weeks. It is unpaid and job protected, meaning that the employee is entitled to resume their former position or a comparable position if the original position doesn't exist at the end of the leave. The purpose of the leave is to provide care and support to one or more family members in a defined class. I'll speak to that in a moment. If a qualified medical practitioner has issued a certificate indicating that the family member has a serious medical condition and there is a significant risk of death occurring within a period of 26 weeks or less. The list of family members is very similar to the list that I went through in connection with the personal emergency leave. It's a bit longer, so if you have one of these situations, I recommend you go on the MOL website and check it out. The earliest that the family medical leave can start is the first day of the first week of the 26-week period identified in the medical certificate. And in terms of how long the leave can run, if the individual family member dies, then that's the end of the leave, or it can go as late as 52 weeks following the same first week in the 26-week period. So the 28 weeks do not have to be taken consecutively. They can be taken in chunks, and they can be extended over as much as 52 weeks. And in that event, there is no need to renew the medical certificate, which was provided at the front end of the process.
Sick leave, family responsibility leave, and bereavement leave were introduced with the November 2018 amendments to the Employment Standards Act. And these 3 leaves replaced the personal emergency leave that had been introduced to the Employment Standards Act with the November 2017 amendments. The personal emergency leave provisions that had a lifespan of only 1 year from November 2017 to November 2018 provided all employees with 10 days of job-protected leave, 2 of which had to be paid, for their own personal illness, injury, or medical emergency, or for situations involving the illness, injury, or medical emergency of certain defined family members. So that personal emergency leave has been removed from the ESA with the November 2018 amendments, and in its place are these 3 leaves of absence. So now all employees are entitled to 3 days of unpaid sick leave, 3 days of unpaid family responsibility leave, and 2 days of unpaid bereavement leave. And the criteria for using those leaves are summarized briefly in the table on the screen. For all 3 of these leaves, they are available to all employees after they have 2 weeks of employment, and the employer can require reasonable evidence from the employee to support their claim for the leave. Now, with the personal emergency leave provisions, there was a specific prohibition on employers from requiring the employee to provide a medical note to support their claim for personal emergency leave. That prohibition has been removed with the November 2018 amendments, meaning that an employer can request that the employee provide a medical note if they state that they are unable to attend work for medical reasons and are wanting to use their sick leave.
There are some general provisions in the ESA which provide for certain protections for employees who access the various leaves under the Act. The first area is benefit plans. The employees are entitled to participate in all types of benefit plans while they are on leave, and the employer is required to make its usual contributions so long as the employee is making his or her contributions. In terms of the impact of the leaves on the employment duration of the employee, essentially there is no impact. The employee continues to earn seniority and service. That's a statutorily protected right. The only exception to that is probationary periods. They are interrupted by the leave. As I've mentioned in connection with previous slides, the ESA contains some very strong provisions which require the employee to be reinstated by the employer to the position most recently held with the employer. But if that does not exist, perhaps as a result of a restructuring or for some other business reason, then a comparable position, and comparable is typically interpreted as comparable in terms of pay, but could involve other considerations as well. There is some case law around this, and one of the cases that I have found instructive over the years is the TDSB case decided in 2005 by the Ontario Court of Appeal. In that case, a teacher returning from leave demanded to be returned to her, and I'm just going to make this up, grade 3 French class, which was the class that she had left on leave from. And the board said, no, you're a duly qualified teacher and you can teach, and I'll make this up again, grade 5 English. And the board was successful. The Court of Appeal found that the reinstatement right was to the position of teacher, not to a particular classroom or assignment. Moving to termination and severance. In many cases, there is no question that a termination has occurred, but there are cases in the gray zone. So the Act does define termination. So it's a dismissal or refusal to employ the employee. It's constructive dismissal, which includes a resignation in response to whatever it is that's alleged to be the constructive dismissal. And it's a layoff that is longer than a temporary layoff. Constructive dismissal generally involves a situation where the employer unilaterally, without the consent of the employee, changes a fundamental term of the employment relationship. It can't be a minor or ancillary term, it has to be fundamental. So any significant changes to hours, salary, demotion, change in reporting relationship, etc., can constitute constructive dismissal. Also, the creation or maintenance of a poisoned work environment, perhaps tainted by racial or sexual harassment and discrimination, that could be the basis of a constructive dismissal as well. The ESA contains the notion of a temporary layoff, which generally speaking is a layoff of not more than 13 weeks in any period of 20 weeks. There's an exception to that. If certain payments like benefit payments are made, then the length can be extended up to 20 weeks as opposed to 13. Under the ESA, if the layoff extends beyond these timeframes, in other words, the employee is not recalled to work within those timeframes, then there is deemed to be a termination, and whatever termination notice / pay and potentially severance pay is owed under the ESA is owing to the employee. It's confusing because many employers think that this is the law for all purposes, but under the common law, meaning the judge-made, court-made law, a layoff or even the imposition of a unpaid suspension in certain circumstances of only a few days could be a termination for common law purposes as opposed to the ESA, and there could be significant financial consequences as a result. So if you're dealing with a situation of layoffs or similar circumstances, be aware that there's a difference between what the ESA says and what the common law says, and you should probably get some legal advice to guide you in those circumstances. This scenario is taken from an actual case called Farber versus Royal Trust, which was decided by the Supreme Court of Canada in 1997, and it's one of the leading authorities on what constructive dismissal actually is. It reinforces that the changes made unilaterally without the consent of the employee must be fundamental, and in this case it was found on the circumstances in the case that such a change had been made, and accordingly Mr. Farber had been wrongfully dismissed, in which case there are common law damages which exceed ESA entitlements significantly in most cases awarded. This scenario just reinforces the anti-reprisal provisions of the ESA because they protect employees who exercise or attempt to exercise their rights under the Act. And obviously, the fact that Bob was terminated the day after he pointed out that the employer was not complying with the Act constituted an act of reprisal. This slide simply amplifies the circumstances under which an employee may not be disciplined, terminated, or otherwise reprised against. So they include asking the employer to comply as per the previous slide, filing a complaint, exercising a right, which could be as simple as calling the Ministry of Labor, or providing information to an employment standards officer. As a general matter, it is open to an employer to terminate any employee at any time for any reason without cause. And if that step is taken, then there are certain obligations on the employer owed to the employee. The first general area of obligation is the provision of either written notice or pay in lieu of that notice. That's called termination notice / pay. The second area is severance pay, and termination notice / pay is owed to every employee who has been employed for more than 3 months. Severance pay, as will be detailed in a subsequent slide, is not owed to every employee. There are conditions that operate in connection with severance pay. If termination notice is given, then the employee is expected to work as per usual, and the employer is expected to pay the employee and pay benefit premiums, etc., as per usual. This slide sets out the Act's requirements with respect to the termination notice / pay in lieu of notice. As you can see, it's generally 1 week per year of service, and it is capped at 8 weeks. So an employee with 26 years of service doesn't receive any more than 8 weeks notice or pay in lieu of notice on account of this particular entitlement. If the employer fails to provide the written notice, then the employee's entitlement is a monetary one, and it is essentially a lump sum payment equal to the regular wages for a regular work week times the number of weeks owed under the chart on the previous slide. I will say that most of my employer clients do not use written notice, which is sometimes referred to as working notice, because there are certain risks that go along with it, including the employee becoming sick, the employee sabotaging something at work. The morale goes through the floor. As you can imagine, there are a number of issues associated with working notice. So most of my employer clients will just cut a check equivalent to the termination pay entitlement. Severance is the second potential entitlement that I mentioned a few slides back, and there are conditions on that, which I'll cover 2 slides from now. But essentially, severance is owed in the circumstances described on this slide and the next slide, which interestingly you will note are go beyond the definition of termination for the purposes of termination notice / pay. This slide shows the further circumstances in which severance may be owed, which, as I just commented on the previous slide, go beyond what the definition of termination is for the purposes of termination pay and notice under the termination provisions. As previously mentioned, not every employee is entitled to severance pay. There are 2 conditions, both of which have to be met. The first is the employee has to have at least 5 years service with the employer, and secondly, the employer has to have an annual payroll of $2.5 million or more. So it's only larger employers that have this obligation towards their employees. If one of those conditions is not met, then the severance pay is not owing. Severance pay itself is essentially regular wages for a regular work week. However, the obligation is potentially much more significant than for termination pay and notice, because it's 1 week per year of service up to a maximum of 26 weeks. And part years under severance, but not termination, are to be, there's to be a prorated amount paid on account of part years. So a very long service employee is potentially entitled to 8 weeks for termination notice / pay and 26 weeks for severance pay. So a lot of money